Not long ago, the issue of how long a lawyer has to keep old files raised its head again. This issue has come to the fore time after time after time, and unfortunately we have no better answer than we had last time. There is a duty of safekeeping for original documents. These documents can never, ever be destroyed. They can be returned to the client if you're fortunate enough to find the client and get the client to take back the documents. But some lawyers prefer to keep the documents as sort of a toehold, if you will, to retention of the client or the heirs of the client at some future time. Nevertheless, the duty of safekeeping mandates that there not be a destruction of those files. Another general mantra can be used here as to when files can be destroyed. They can be destroyed when it's reasonable under the circumstances to do so. For me, that's not particularly satisfying, because for me, every 2 or 3 years, if you go through and clean house, that seems to me to be reasonable. But of course, in the legal community, we all know that that's too soon to destroy files. So, when else might the mantra work? Well, when your jurisdiction has a definitive time provision, such as 10 years, as some states do. Check your jurisdiction to see whether it has a time set, a time certain for your being able to destroy files. And another mantra or aspect of the mantra might be when your client agrees to the destruction. And particularly here, not to the destruction of particular files, but to a destruction protocol that's set forth in your engagement agreement. I'm sure most of us, if not all of us, have no such provision in our old engagement agreements. So we're stuck with years and years and years of boxes in storage where this provision would not apply. But in all your new engagement agreements, you do yourself a favor by inserting a provision there that says that the client consents to the destruction of the file at the end of a certain time period, whether it be 5 years or 7 years or 10, whatever it might be. That consent will hold valid. Here are some other provisions that you might consider for the minimum time frame. One, the time passage for filing a malpractice action. Clearly you don't want to destroy anything in the file that might be useful to you in particular in the event a malpractice claim is filed. The passage of time for lawyer misconduct. And I guess here the parenthetical question would be, is there such a statute of limitations? I've never heard of one. And if that be the case, then you might want to keep this file forever. When there's enough time passage that equals the time frame for the destruction of client trust account documents. And in each jurisdiction that might be a different number, for example 6 years, after which time you can destroy the client trust documents that support your entries and so forth. That might be an appropriate time, certainly as a minimum, to destroy the client file documents. Another minimum time frame might be time equal to the destruction of corporate and tax records. But as somebody once said to me not long ago in connection with this, there is no statute of limitations on murder, there is no statute of limitations on lawyer misconduct, and so it might behoove you to keep those documents. Oh, and what happens to the lawyer who retires, to the lawyer who merges or sells his practice? What happens to the lawyer who dies? What happens to those files? Well, if you die and your estate now is responsible for your law practice, or certainly the documents in your law practice, according to the state of Maine, in a decision I read a number of years ago, the heavy hand of the bar reaches right into the grave. It is the lawyer's responsibility to anticipate that he might die and therefore take care of the devolution, if you will, of the documents. Now, that not being the case, in most cases, is that lawyer guilty of negligence, malpractice, for failing to take care in advance of his death of the client files? An interesting thought, seldom, I'm sure, litigated, but it behooves us then perhaps to create an estate plan for your practice. In other words, make arrangements with somebody other than your administrator, your executor, who may or may not be a lawyer, to come in and do what's necessary to clean up your practice. I think that there's a solution here available to us technologically that we haven't mentioned before, and that is you can scan all the documents within a file and convert all that paperwork into electronic format. Yes, save the original documents, put them into safekeeping storage, but all the other documents can be scanned and electronically available, and then you can destroy the physical evidence, so to speak, the physical documents. And scanning electronically in today's world isn't that expensive. If you need help with this, give me a call and I'll make some suggestions to you that I know a Chicago law firm has implemented quite successfully. They're able to do good by doing right, to do well by doing good. Thanks again for joining us today.